Moving on Tuesday, the Supreme Court officially transmitted their decision to overturn Roe v. Wade to the lower courts. But wait a minute, did the decision come out a month ago? Well, WTF is that? Actually, the opinion came a month ago, yes, but this is called when the judgment is issued, which means it's actually part of the law now. The Supreme Court rules state that after an opinion is rendered, a certified copy of the judgment must be prepared, signed by the court's clerk. And that usually takes about a month. And it may sound like red tape, and it kind of is, but a number of states were actually waiting for this to happen to begin enforcing their new abortion bans. That includes the likes of Idaho and Tennessee and Texas. But it isn't going smoothly everywhere. In fact, in Wyoming, a judge blocked the state's new abortion ban on the very day it took effect. The judge sided with a firebombed women's health clinic and others who argued that the ban would harm healthcare workers and their patients, and they claimed that the ban violates the state's constitution. Meanwhile, in Georgia, the ACLU is suing the state over their abortion law, which effectively bans most abortions, after 6 weeks of pregnancy, which is before most people even know that they are pregnant. Now, the law was blocked before going into effect, but then unblocked recently. This new lawsuit now asks the Fulton County Superior Court to block it again, and the ACLU reps say part of the law is too vague and it puts patients at risk.
The limited and vague medical emergency exception to this ban would force patients to the brink of death before they could get the care they need.
The lawsuit also includes a challenge to part of the law, which gives prosecutors access to abortion patients' medical records, arguing that that violates the state's privacy laws.